You have the call.
Thank you very much, Chair. Minister Secretary, I've got some questions about the government's commitment to accessibility in the realm of childcare. And these have arisen through a constituent. I'm not particularly familiar with them, but the constituent's got some concerns. So I want to ask, is it statute that has determined the accessibility guidelines, or is it regulation?
Senator Jackie Wilson, Deputy Secretary of Children and Childcare. I'm just trying to clarify what it is you're talking about. Is it access to service? And
Yeah,
I'm thinking like priority of access guidelines is what you're saying.
Exactly
is that right?
Yes, that's it.
Okay.
Priority of access guidelines.
So they're in guidelines, they're not in legislation.
Okay.
And priority of access guidelines are consulted on, and then we sort of finalise them and the Minister endorses them. The kind of groups that priority of access guidelines apply to are children at risk,
Yep.
children with disability, there's a whole range, and they were all consulted on, and we've recently consulted on those again ahead of the new legislation.
I understand that because I have seen the guidelines here. I'll tell you the story though, that a gentleman was asked by the childcare centre where his child was being placed to sign a form which said, in the event there is a waiting list on this and a child of Aboriginal extraction from a low socioeconomic group from one of the guidelines there, we can require your child to be removed from the childcare and to be replaced.
Okay.
That doesn't seem right to me.
So, Senator, and that's an interesting thing you're saying, because we have the priority of access guidelines, but in general they're applied to vacancies, so spaces that people have in a service to fill, rather than putting out existing families to create a place for one of those groups on the priority list.
Well, I don't want to contradict you, Ms Wilson, but I do have some information here. And this may be outdated, you can tell me if it was, and I'll just like to read it to you. It says, subject to the preceding provisions, where the service has no vacant places and is providing childcare for a child who is a third priority under Part 2 of the schedule, the service may require that child to leave the childcare service in order for the service to provide a place for the higher priority child, but only if they give 14 days notice and the person that they're kicking out was told at the time of the enrolment that that may take place.
So my understanding is that is what the guidelines say, but my understanding is in practice what happens is the centre negotiates a successful outcome where they can take on board that child who has a priority of access without displacing others. So I've heard service providers talk to me in workshops about adjusting hours, consulting other families, trying to negotiate to find a solution around that.
Okay, Ms Wilson, that's great. You've got that anecdotal evidence, but that's not what the guidelines say. That's not what a father or a mother who takes their child to a childcare service is given a place, is asked to sign. They've been told that their child could lose their place because another child comes along who happens to have Aboriginal parents or happens to have a disabled parent or parents who are dysfunctional or comes from a low socioeconomic group. That is wrong.
So, Senator, I don't have the guidelines in front of me and just want to check the extract you gave before.
This is the priority access guidelines.
You said a service may essentially displace a child. That's the
It doesn't say it will.
No,
it says
it doesn't say must
That's my point.
or will, that it is a choice then made by the individual service in those circumstances.
But do you see the point, right? The point is, someone goes and gets a place in a childcare centre. They're not displacing anyone else. There's a vacancy there. And when they're presented with a document and asked to sign it, that their child could be turfed out because someone deemed it more worthy on the basis of their ethnicity or their parentage or anything else, they could be turfed out and they're asked to sign it. That really annoys the heck out of my constituent. It's your constituent too, Minister, I should say. But it really annoys the heck out of them. They go, well, what's wrong with this? I'm out there working, my child needs childcare, and suddenly they could lose their spot.
So, Senator, I mean, you're raising a circumstance that I have to say has to my knowledge, never been raised with me before.
This is me.
It obviously is a choice that can be exercised by the provider. If a provider, and obviously, even in your circumstance, you're not saying that it occurred, but you're saying that a parent was advised that it could occur.
They had to sign a form prior to entry
Saying they
acknowledging
had
that
been
this was the
advised that it
case.
could occur.
And that caused them distress, and I think quite reasonably distress, and particularly given the fact that childcare is meant to be accessible to everyone. You want 1.3 billion, I think, extra dollars to make it more accessible and more affordable coming up. And I think it just seems absurd to me that we have this provision in there.
So, as Ms Wilson has indicated, we're out consulting on new guidelines associated with the new legislation at present. You raise an interesting point that I'm more than happy to make sure we look at properly through those guidelines as to circumstances perhaps where a child at risk of serious abuse or neglect needs to be accommodated is obviously rightly a high priority circumstance for consideration through any
ancestry,
reforms.
Minister? Ethnic origins, is that...
I'm just looking at the first priority topic that it says on what I've been given here, which is a child at risk of serious abuse or neglect. So we are consulting on new guidelines. If you have an example where it's actually occurred, which from what I can tell from your questioning you don't, but if you have a circumstance where it's actually occurred where a child has been turfed, to use your word, from a service, then I'd be interested to dig through that. But we will certainly go back as part of the consultations with the sector to see how it is being applied, whether the guidelines for the new scheme need to be clearer and tighter in regards to application of them.
So is there a requirement then for a childcare provider who is using these guidelines to notify you if they displace a child because of another child's demands?
There's no requirement to notify, Senator, and I guess Ms Pearson and I were just commenting in 3 or 4 years in the job, we've never heard of anyone being displaced. We did recently consult on these guidelines as part of the recent round of consultations, and everyone has asked for that statement to be removed. So in the consultations, that it makes clear that the priority of access areas only apply to new vacancies, not about displacing existing people, because the point that was made, Senator, was that that is not what they do in practice. They don't actually displace someone to find another place, and so it was best to restate it in a different way.
So it's not going to be there anymore?
That's right, Senator. That's what we're going to be proposing to the Minister.
That's encouraging.
I look forward to seeing that, Ms Wilson.
The Minister has to approve that, doesn't he, Minister? Okay, in relation to those guidelines, though, was there ever any legal advice that the department received or any other advice about whether they complied with state anti-discrimination laws, etc., or even Commonwealth anti-discrimination laws?
Not that I'm aware of.
We'll have to
Senator.
take that on notice,
We'll take it
Senator.
on
It was
notice.
quite a long time ago.
Well, yeah.